Good afternoon, everyone. My name's Jill Cohen. I'm really excited to be able to be with you this afternoon for Workforce Compliance for Cannabis Businesses, a legal overview. For those of you who know me and are clients of mine, one of the best things about joining Verrill was having access to the great team in our labor and employment department. So I am going to kick this over to my colleague, Tani Alvarez, to introduce today's program.
Thanks so much, Jill, and welcome to everyone. Thank you all so much for being here. My name is Tani Alvarez. I am a partner in Verrill's Labor and Employment Practice Group. My whole practice is based off of advising businesses as to best practices concerning managing their employee workforce. With me today is Hannah Satterley, a colleague of mine in the Labor and Employment Practice Group. And we both very much enjoy supporting Jill and her cannabis clients after her joining Verrill. So one of the really cool things since Jill joined us is the fact that we get to work with her clients. We get to understand kind of the business and industry that you're in. And now that Jill's been with us a couple of months, we were able to identify as a team, gosh, Jill, these are some things that I think it would be really helpful for your clients to know and understand related to labor and employment law. And that is why we are here today. We're going to be focusing really in on an overview of key employment law principles. So you're not going to get a deep dive into everything. You're going to get a potpourri of all things labor and employment. This is a presentation that Hannah and I could do that could take up 8 hours, 10 hours, 12 hours, because there is a ton of detail in these things. Really, today's goal is to get your mind moving on different things that we see regularly with organizations in your industry and just in general for organizations of each of your size. So a couple of quick notes, however. The today's session is being recorded. So after the session, you'll get an email that has a link to it as well as the slides. So don't worry about kind of jotting everything down because you are going to get a copy of this. Additionally, if you currently have any licenses or certifications, this webinar has been approved for one SHRM credit and one CLE credit. If you're an attorney, we'll submit your name to the main bar for CLE credit. And we're also going to email you a certificate for your records if you're seeking SHRM certification. If during the course of the presentation you have any questions, please use the Q&A box and we're going to do our best to answer those questions in real time. And with that, let's begin and go to that first slide.
Tawny, just one other thing,
Yeah.
because I know that Verrill wants me to remind you, the CLE credits are pending. So
Oh,
um, those will be finalized soon.
perfect. Thank you, Jill. So, anyone who's ever attended any webinars we've given in the past, it's really important for me that you walk away from this session feeling like you took something important away from it. So I'm going to provide an outline of the agenda. If in looking at this agenda, you're like, none of this matters to me, Tawny, I could care less about this, it's a good time to leave. If there's something on here that you're like, why aren't you going to talk about this, Tawny? I just don't want you to be disappointed at the end that we didn't talk about it. Email Jill, Hannah, or I offline to talk about kind of that issue more generally. So today, things that we're going to talk about both in a general and in some cases specific area. Why is employment law important? Kind of why is it something that you should have at top of mind regarding the work that you're doing? What are best practices concerning hiring and managing employees? This is going to be a potpourri of things, but really focusing in on things that the cannabis industry should kind of have at top of mind. As it relates to that hiring, we're going to talk about background checks and also common cannabis wage and hour issues. So how we pay employees, the rate of pay, the timing of the pay, breaks, anything regarding to the hours that people are working and the pay that we're providing. I-9 compliance, making sure that your federal documentation concerning employees' eligibility to work in the United States is appropriately completed. Surveillance considerations. We're going to talk a little bit about some pending legislation in Augusta, what that means to all of you who use surveillance regularly and required to do so under the cannabis regulations, and other aspects that you need to consider instituting from a policy perspective for best practice purposes. We're going to talk a little bit about protecting intellectual property and goodwill. We're going to talk about employee handbooks and policies that should be at top of mind, and then employee relations. This is going to be a general grab bag of the things that in the first couple of months with Jill really are at top of mind for us as things that you all need to be considering. So with that, we'll jump to the next slide and we'll let Hannah jump into discussions of why employment law is so important.
Thank you. All right, so we certainly understand that there's many priorities when starting and maintaining a business, and that employment law might not be on the top of your mind, but as we'll sort of discuss in a lot more detail, employment law plays a critical role in shaping the relationship between employers and employees. And understanding the importance is key to managing those relationships effectively. So first, personnel can be an organization's greatest asset, but also its greatest liability. So employees are often the backbone of the business. They drive productivity. But when employment issues are mishandled, they can lead to costly disputes, reputational damage, and legal liability. So employees have a duty to perform the tasks assigned to them, but this duty is balanced by the employer's responsibilities. So employers have several key obligations. These include maintaining a safe work environment. You have to ensure that employees are not exposed to certain hazards, creating a workplace free from retaliation and discrimination, fostering an inclusive culture that complies with both federal and state anti-discrimination laws, and paying employees appropriately for the work they perform. This means following wage and hour laws, including things like minimum wage, overtime, and timely payment requirements. Employment law can be complex because both federal and state laws apply, and sometimes with overlapping or conflicting requirements. This is especially true in regulated industries like cannabis in Maine. For example, Maine's cannabis regulations specifically state that licensees must comply with all applicable employment laws. So safety, wages, hours, just like any other employer, there's no exemption from these responsibilities simply because of the nature of the business. Next slide.
One thing just to add to all
Yeah.
of that, is even though you're talking to three attorneys, so this is probably a nightmare for most people. You're like, yeah, spend an hour with three attorneys. That's no fun at all. We very much believe in the importance of, having other team members kind of involved, seeing if you can find someone who'll write EPLI insurance for you. So employee practices liability insurance, right? If you don't have that, talk to your agent. See if someone will write it for you. And what that's going to do is help protect you against employment discrimination claims. So claims that you retaliated against an individual, you didn't hire them for as a result of a protected class, anything along those lines, talk to your agent. We do believe a team mentality, having the right people in the banking industry, having people um, in insurance, and having, solid legal advice are all important aspects of managing your business.
And as we jump into the first slide, if I may, as a general proposition, because the regulations are up to date for the adult use program, you will see that these slides are geared towards adult use compliant. As those of you know who are operating in the medical side of things, the medical regs haven't been updated since 2018, and so they don't track state law. So where applicable, you may hear me jump in with the med side of things. So don't think we're overlooking caregivers and dispensaries. All of these things are important for you as well. So I'll jump in as needed with the medical side of things.
So for hiring and managing employees, especially in the cannabis industries, there's a few unique requirements that employers should keep in mind. And I'm sure a lot of you already know a lot of these things, but employees are required to be at least 21 years old. And many employees will need to obtain proper identification before starting work. These are different depending on whether you're working in the adult use or medical cannabis market, sort of as Jill was just saying, and I think we have maybe a question that also addresses that. But for adult use, employees must obtain an individual identification card, or IIC, before they start work. This card is mandatory if the employee is performing certain tasks like handling cannabis or cannabis products, whether that's cultivating, packaging, testing, or delivering them, and also accessing or inputting data into the inventory tracking system, or acting in a leadership role or controlling authority in the business's operations. And then in the medical cannabis program, employees who perform those similar functions that I just listed are required to obtain a registry identification card, or an RIC, before starting work. And the RICs serve the same purpose as the IICs, but are specific to the medical program's regulatory framework.
One
Properly
small
vetting.
caveat. Oh, sorry, Hannah.
Yeah, no, go ahead.
On the med side of things, there is a carve out for relatives of caregivers between the ages of 18 and 21 years old, and they can apply for an RIC to work in a family business. That is the only exception to the 21 and over requirement.
And so what we just sort of wanted to highlight is that properly vetting during this hiring process and maintaining clear policies on these requirements is really important and can help you avoid regulatory issues and just ensure compliance from day one. Next slide. So conducting background checks is a key part of the hiring process, especially in a highly regulated industry like cannabis. Background checks help employers to make informed hiring decisions, promote workplace safety, and ensure compliance with licensing requirements. However, it's essential to approach this carefully to avoid any potential legal pitfalls. So if you're using a third-party agency or credit reporting agency to conduct your background checks, the process must comply with the Fair Credit Reporting Act, or the FCRA. This sets out important protections for applicants, like you have to obtain the applicant's written consent before running the check, and provide notice if you make any adverse employment decision based on the report. Using a reputable third-party service that knows what they're doing and has experience in the area is typically what we recommend. They can provide a more comprehensive check while ensuring compliance with federal regulations, which can help reduce your liability and ensure that the sensitive information is handled appropriately. We do recommend, if you're conducting informal background checks, like if you're reviewing people's social media or other online information, it's best to have someone outside the direct chain of command perform the search. Sort of reduces the risk of bias or allegations of discrimination if information unrelated to the job is discovered during that check. Finally, as part of the background check process, it's important to confirm whether the information can obtain or already holds the required IIC or RIC. Another important note on this, which I think Jill can maybe speak more clearly to, surrounds submitting a plan of approval before becoming licensed. One of the questions surrounds a business's background screening process, which is often an area that Jill sees some kickback or additional questions on if the right narrative isn't provided. Jill, do you want to add anything?
Yes, yes, just briefly. Thanks, Hannah.
Yeah.
So the Office of Cannabis Policy no longer conducts background checks for the issuance of an IIC, an individual ID card for the AU program. So for those of you who are the licensee, you're familiar with the plan of record. There is a question on the plan of record that asks how you intend to conduct background screening on your employees. And what the Office of Cannabis Policy expects is that you do have some system in place to conduct an amount of background screening on your employees, because the state no longer does that for you. So it is part of your plan of record as a licensee.
I think we can move to the next slide, and I'll hand it back to Tani.
So we're going to jump into discussions about wage and hour issues. And as Hannah mentioned earlier in the presentation, one of the things that you need to keep at top of mind whenever we're working on a situation like this is that both state and federal law are applicable to the organization. One of the things we run into a lot of times is a client will contact us after they've Googled something and they've said, well, Google told me this. And when they send me what they're looking at, come to find out it's law from London or it's law concerning Kentucky's regulations, right? We're really focusing in on federal overarching laws and regulations concerning engagement with your employees as well as Maine law. The law that's going to apply is going to be the law of the state in which the employee is working on. Most of you on the call today should be operating in Maine. If you have remote employees who are doing something, unrelated to you know, touching, handling, distributing cannabis more generally, who are doing some very random kind of job, those are going to be other discussions, both that you're going to want to have with Jill and with I about how we're handling remote employees and what laws are applicable to them. Another area where we see a lot of discussion, especially with smaller businesses, are independent contractor issues. Startups oftentimes rely upon independent contractors without understanding many of the risks that are associated with that classification and treating people as independent contractors versus employees. With that, let's jump to the next slide and really talk about minimum wage and overtime. So under federal law, the law is called the Fair Labor Standards Act, and then we also have state law, the Maine Wage Act. They define work as what's known as suffer or permit to work. It's a key phrase in all things labor and employment. When someone suffers to work, it's when they are put on the schedule and told, okay, these are the dates and times that you're working. When someone is permitted to work, it's when they love and adore your business so much that you can't get them to leave. One of the things we hear a lot about is this employee isn't scheduled to work, but they really, they love the business so much they want us to succeed that after their shift is done, they stay around and they do these other tasks because they want to volunteer. There's no such thing as volunteering for a for-profit business, and none of you are nonprofits. So none of you should have any volunteers, right? Every single person who's providing services to your organization should either be employee or an independent contractor who is getting wages for all of the time in which they work. Those wages should be either an hourly or in salary. So hourly, the wage needs to be above $14.65, or if you're located within the city of Portland, over $15.50. That's for the first 40 hours in which they work. If anyone works above 40 hours in a week, you need to be paying them time and a half, right? A lot of times people say, well, what is a week? The cool part is the law allows you to define what a work week is within your organization. A work week doesn't have to begin on Sunday morning at 12:01 a.m. You can have your work week begin on Wednesday at 8 a.m. with the understanding that you need a 7-day period between the start and the stop. Why is this important to identify what a work week is? Because you need to know when 40 hours has been worked and when overtime is necessary for individuals who may be working 45, 47, 50 hours so that you know how many hours need to be paid at that overtime rate of time and a half. Some states require that if you work on a weekend or if you work on a holiday or if you work more than 5 days, that you get some type of bonus or additional pay. In Maine and under federal law, the only time that time and a half is required is after you've worked 40 hours in a work week. It's also really important that you define the regular pay dates. So under Maine law, within the end of a pay period, right? So the end of that work week, you have to pay within 15 days of that pay period. So making sure you have a regular pay date set up is important. There's also these concepts known as exempt or non-exempt under state and federal law. Exempt means that you can work over 40 hours and not receive overtime. And non-exempt means somebody who is entitled to overtime for hours worked in excess of 40. Not everyone who you give a salary to is considered exempt. So you can't just say, don't worry, Tawny, I pay them a salary, so I don't have to pay them overtime. In order to be entitled to be exempt and thus not have to pay overtime, you have to pay a salary of above $43,951. And they also have to do tasks and duties um, that are that fall within a different category within each organization. So there's a job duties test and that there's a salary provision. And the most common forms of salary exempt exemptions are professional employees. So those would be doctors, lawyers, someone with advanced degrees in science or learning, sometimes engineers, certain scientists, a executive exemption, so someone who oversees the work of two or more individuals and exercises discretion and control over matters of significance within the organization, and administrative employees or individuals who exercise discretion and control, have that salary above 43,000, and that their work is kind of overarching on managing the organization. They may not be overseeing two or more individuals, but they may be doing stuff such as IT work for your organization, marketing. They're doing something outside of the operation of itself, whether or not that's the sale or the manufacturing of cannabis. Um, Additionally, it's important to acknowledge whether or not these employees are part-time or full-time. How many hours per week can they expect to work? And are they year-round or seasonal? In the next slide, Hannah's going to talk about independent contractors. And what we hear from people a lot of times is, no, Tanya, I made this person an independent contractor because I only need them for 2 months, 3 weeks, 4 days. It doesn't matter how long you need an employee for. That's not the determining factor as to whether or not you treat someone as an employee or an independent contractor. So make sure you understand each of these different classifications. Additionally, under Maine law and under federal law, most people are considered at-will employees. That means that the employer or the employee can terminate the relationship as long as they're not doing it for an illegal reason. What would an illegal reason be? I'm terminating you, Tawny, because you're a woman. I'm terminating you because you're white, or I'm terminating you because I don't like your religion. Those would all be illegal reasons. But you know what, Tawny? I just don't need you anymore, or your work quality isn't good. An at-will employment arrangement allows that to occur. If you enter into a contract with someone and promise to employ them for a period of time, though, then you have a contractual relationship and you've limited your ability to terminate that person based off of what's set forth in the contract. We've gone over overtime and the importance of kind of maintaining when your 40 hours starts and stops and making sure you're paying at time and a half for time after. But one of the things we haven't talked about is, well, how do you track the time that it's worked? For all of your non-exempt, your hourly employees, you need to have them tracking work time in some format, when they start working, when they stop working. If somebody puts on their pay stub, I started work at 8 and I left at 5, but you know that they were still in your facility at 7 o'clock doing things, even though they weren't suffering to work, you permitted them to work, and you're going to have to pay them for that time between 5 and 7 because they were still providing services to you. Additionally, all employees who work 6 or more hours during the course of a day are entitled to a half-hour work break, lunch, rest break. It can be for lunch. It can be just to, step out of the building. It can just be to scroll on their phone and not do work. But that half-hour rest break needs to be provided unless you have a signed break waiver on file for the employee. If that's something that you're interested in, reach out to Hannah and I, and we're happy to work with you to create a break waiver and then discuss with you what that means. With that, Hannah, why don't you go into some detail about some of this independent contractor versus employee type discussion?
Sure. So as Tawny kind of touched on, properly classifying workers as independent contractors or employees is a critical decision. Misclassification can expose you to significant legal and financial liability under federal and state law. The most important point that I want you to take away from this slide is that simply having a contract that labels someone as an independent contractor doesn't automatically make them one. Courts and administrative agencies like the Maine Department of Labor or the IRS will look at the actual nature of the working relationship to determine a worker's proper classification. So this means they'll consider factors like the level of control that the business exercises over how an employee's work is performed, whether the worker is economically dependent on the business or truly operates independently, and how integral the work is to the business's core services. Misclassifying an employee as an independent contractor can have serious consequences. While independent contractors are not entitled to certain legal protections, such as things like minimum wage, overtime, or workers' compensation, misclassified workers may still be eligible for those benefits, even if both parties, you and the worker, agreed to the independent contractor label. If you are engaging independent contractors, keep in mind that employers can avoid certain tax payments and insurance obligations, but this does come with a greater legal risk if the classification is challenged. Independent contractors aren't covered by key employment laws like Title VII, which is discrimination laws, the ADEA, which is age discrimination, or the ADA, which is disability accommodation. Workers' compensation coverage typically doesn't apply, but this does raise questions about who pays if an injury occurs at work. And misclassification can also affect the business's general liability exposure and whether the worker can bind the company to contracts. Ultimately, misclassification can result in back wages, tax penalties, and different legal damages. I want to be clear, I'm not saying that there aren't pros to having independent contractors. There certainly is, especially in small businesses, but what we want to make clear is that it's really important that we take a look at how we're classifying workers and whether we've done that correctly. The next slide.
Oh, actually, so one, well, actually,
Go ahead.
one other thing, we're talking a lot about like risk, liability, and some of you may be thinking to yourself, Tawny, none of my employees are ever going to sue me. They're my best friends, right? You don't just have problems with the people who are in your organization, some who may be your best friend, but Jill, Hannah's job is to recognize that they might not always be your best friend. Like something might happen in the future where the relationship falls apart in some format. Not just that, however, but the Department of Labor is also there. So you're used to dealing with administrative agencies, but it's not just will an employee sue me for these things. The Department of Labor can come in and audit all your books and records. And if they determine that you're improperly classifying an individual as an independent contractor as opposed to an employee, they're going to fine you for all the taxes that you didn't pay. They're going to fine you for unpaid wages, for unpaid overtime. There'll be penalties associated with all that. Not just those elements, but also if there is an injury, the great part about having employees who get injured and you're like, whoa, Tawny, like, how is there a good part to it? The good part is you have workers' compensation coverage. You're not paying out of pocket for any of that. We deal with every day serious injuries at work, right? If the employer had to pay for medical coverage for those injuries, it's enough that it could put a business under in some situations. If you have workers' comp coverage, however, that's all of your liability. You don't have to worry about future pain and suffering or future medical costs. Your insurance company is going to handle that. So just another element to keep in mind. Jill, anything to add before we jump into like what is an independent contractor in detail?
No, I mean, as we discussed in the run up to this event, I think where this really comes into play in the cannabis industry are trim services. I think that is probably the biggest example, seasonal harvest help and trim services.
So Hannah, let's jump into kind of what is an independent contractor under Maine law.
Yeah, sure. And we know this slide is very small, but we will be sending the slides around so everyone can take a look and sort of go back to this when we send them around. But this slide goes through sort of a step-by-step framework on how Maine applies the test to classify workers. It follows 6 steps. Step 1 is the right to control. So does the individual have the right to control the means and the progress of the work, except as to the final results? If they don't, you move. That means that that means that the individual is an employee and you stop right there. If yes, then you move to step 2. Step 2 is independently established business. So is the individual customarily engaged in an independently established trade, occupation, profession, or business? Again, if no, then the individual is an employee. If yes, keep moving. So step 3, profit and loss opportunity. Does the individual have the opportunity for profit or loss as a result of the services being performed? If not, they're an employee.
So
Next,
you see how many times, I mean, you got to get through a lot of different steps in order to have someone appropriately classified as an independent contractor. I mean, Hannah will go through the last couple of them, but there is a lot of questions. It's not just, do I need this person for 5 days? Or do I know if I have enough money to pay this person for the next year? You know, you have to do this analysis.
The next, which don't always apply, is about hiring and paying assistants. So if there are assistants, does the individual hire and pay their own assistants? And do they supervise their work? And do they bear the responsibility of the assistant's work? And then finally, if the individual meets all of those previous 5 steps, they must also satisfy at least 3 of the following elements. So I won't read through all of them, but these are things like they're not required to work exclusively for one business. They can be held liable for the satisfactory completion of the work that they're doing. The payment is based on the work that they performed and not on how much time they spent on the work that they were doing. And the work is outside the usual course of your business. And so they have to meet 3 of those to be classified as an independent contractor. Tani, do you have anything to add on those steps?
Nope.
All right, I think we can move forward.
So in addition to the independent contractor slash employee discussion, the other place where we see consistent questions or issues in this space is specifically at the startup time when cash is low. Remember earlier I said you cannot volunteer for a for-profit company. If you have anyone who is working for you, family, friends, neighbors, right? They need to get paid. The only people who don't need to get paid are those who have 20% or more equity in your organization, right? So if a person has 5% equity, that's not enough for them not to get paid. You still need to be paying them at minimum wage or a salary. Now, the salary has to be enough that when you divide that salary by how many hours they worked that week, that it's at least minimum wage, again 14.65, or if they're working in Portland 15.50, right? But it doesn't matter how you're organized. If someone is working for you and they don't have 20% equity, you need to be paying them wages. If you're not, they can come back later. There's a 6-year statute of limitations for these type of claims and say you didn't pay me wages. And what they'd be entitled to is looking back those 6 years, however much money you didn't pay them times 3. So it's trebled. And if they went to the Department of Labor, if they got a lawyer and tried to sue you for wage and hour violations, It would be 3 times whatever you didn't pay them. And if a lawyer's involved, you'd have to pay not just cost of defense, so not just Jill or us, but also you'd have to pay the employee's lawyer as well for the costs associated with them filing the lawsuit. So there's a lot of money that's at issue here when you don't pay employees properly. We talked earlier, kind of the only other time where you shouldn't be paying minimum wage is if you have an exempt employee, and that's going to fall under the professional, administrative, or executive exemption test, where you're paying over $43,000 a year, plus you're making sure that they are doing the job duties and responsibilities that are necessary for an exempt employee. And if you have questions about what those duties look like or what they include, reach out to the three of us after the presentation. We're happy to just send you over the federal fact sheets that say this is what administratively exempt requires, this is professional, this is executive, so that you can take a look at that. And if you don't meet that threshold, you're going to need to be paying, above minimum wage and overtime for hours worked in excess of 40. Any Jill or Hannah, anything to add before we start talking about I-9 issues?
No.
Perfect. Hannah, why don't we jump into I-9?
Sure. So this is another important and sort of timely area that we're seeing a lot of action around. So when hiring employees, I-9 compliance is a critical part. The cannabis industry presents especially unique challenges because of some of the tension between state legal cannabis and federal immigration laws. So what do I need to do to remain compliant? We'll talk about it in the next slide. So according to the Immigrant Legal Advocacy Project, or ILAP, non-citizens who use marijuana, even in a state where it's legal, work in a cannabis-related business, or invest in cannabis enterprises can face immigration consequences, including being denied a visa, a green card, or U.S. citizenship. These risks certainly underscore the importance of caution and clear communication when hiring non-citizen workers in the cannabis sector. I'll get into best practices in the next slide. Does anyone want to sort of touch on anything before I move there?
I'll just touch on that, while these consequences are consequences that affect the employee in their individual capacity, Hannah's going to talk about why this is something that you should have at kind of top of mind more generally because of the interrelationship between anti-discrimination laws and kind of employee rights.
So with that, some best practices include adopting neutral hiring practices. So this means treating all applicants the same regardless of their national origin or perceived immigration status. Under federal law, employers can't ask for specific documents or inquire about someone's immigration status before making a job offer. Instead, focusing on whether a candidate has the qualifications for a job is important. So then during the onboarding process, employers can request documentation that satisfies I-9 requirements, but it's important to let the employee choose which documents that they're providing from the sort of list of acceptable options. Next, a really important aspect is conducting regular audits. This can be really helpful and a valuable way to sort of catch and correct any common mistakes. This could be a missing signature, an incorrect date, any incomplete information on the form. Sort of making these proactive compliance efforts is important, and assigning someone from HR or having us perform these audits, especially ideally on a regular basis, and documenting the process is really ideal. If any issues are identified, you can correct the form. There's guidelines online that show you exactly how you can make corrections to certain errors, and then maintain your records showing the steps that you took to fix any of those errors. Violations here can really add up, which is what we're seeing. Fines are imposed not for each incorrect form that you might have, but instead for every error on each form. So even if an employee is authorized to work, but there's a missing signature either from the employer or the employee, that's a violation. Maybe the employee didn't date their signature, that's another violation. So it's really important to sort of go through and make sure that we're doing these correctly. And then finally, just seek legal guidance for any complex cases. Cannabis employers face unique legal challenges when it comes to I-9 compliance, and there's often gray areas around different hiring practices. So legal guidance can be helpful when making employment decisions. Can also be helpful when navigating certain scenarios, like how to handle an employee whose work authorization is expiring, different things like that. Tawny, do you have anything to add?
The only other thing I'd add is for those of you who may be attending and this is your first Verrill seminar, the Labor and Employment Group does this regularly. So actually just a few weeks ago, 2 weeks ago, in fact, we did a whole 1 hour webinar about how to appropriately complete I-9s and how to do an I-9 audit. So how to go back through all your documents and appropriately edit them. I can tell you one thing, it is not by erasing anything, it is not by using whiteout. There's a very specific practice in place, and if you don't follow um, U.S. immigration forms and standards, you will receive additional violations. A copy of that webinar is available on our website on taking care of HR business, as well as you can just Google on our website, you can just search I-9 presentation and it's going to come up, and you have the slides as well as a copy of the whole presentation. So if I-9s is something that you're like, oh, we're doing it, but we probably aren't doing it right, I very much recommend using that resource. These are all free resources. I mean, we put together these resources for free. You don't have to pay for them. You know, use all of this stuff that we're putting out there for you because they're complex topics, and in a lot of situations you can save yourself a couple $100 by watching these videos first, and then if there's something specific, complex, or something along those lines, Hannah and I and Jill can walk through those elements with you on case by case situations. Let's talk a little bit about surveillance. And you're probably laughing to yourself as, Jill and I have had conversations about this, that like surveillance is in all of your worlds. You're all used to being on camera all the time. You know what the regulations provide, but are there different elements that you should keep in top of mind when you look at your industry from a purely employment law perspective? Do those cameras create risk for your organization? And it might be risk. You have to live with that risk, but there's ways in which we can minimize some of it for you, and with hope over time, minimize costs that may be associated with those risks. So let's jump right on to the next slide and talk a little bit about where we find ourselves with surveillance right now from a state and federal perspective. So if you follow kind of what's happening in Augusta to any degree, you might be aware that there's currently this act in Augusta to protect workers from employer surveillance. So with the goal of getting rid of surveillance in the workplace. It is likely that this act is going to pass, LD 949. That's going to create questions in the industry. Wait a second, it says that unless surveillance is strictly necessary to ensure health and safety. In your situation, from a regulatory standpoint, we will continue to need to have surveillance of the property, and we would look at that from a security and safety perspective. If, however, you also have cameras kind of outside of the facility or in areas that aren't necessary or regulated, we're going to have discussions about why do we have it there? Is it for health, safety, or security? Kind of what is the reasoning behind having that surveillance? The other thing that's really important to keep in mind is that notice should be given to all of your employees that surveillance is occurring. Likely, most of you have been in the industry for any period of time are like, well, come on, Tani, everyone knows that they're under surveillance all the time. You don't know what everyone knows. The fact, some of the scenarios that Jill, Hannah, and I deal with, sometimes we like look into the sky and be like, are you kidding me right now? Like, how is this their perspective, or how did they not know this was occurring? Instead, have a policy in your handbook that very clearly says, while you're on site, you need to understand that you are being monitored at all times, that the only place that there isn't monitoring is in the locker room or a bathroom. You know, you can identify the places where there is not monitoring, but making sure that people understand that they have no expectation of privacy in these spaces is really important, so that you don't later get some complaint of, I was being harassed because you were watching the videos of me and I don't feel safe at work anymore because you were watching the videos of me and that makes me feel uncomfortable. You know, some of you may be saying, come on, Tani, these are actual facts. These are situations we've dealt with in the past where, you know, if we can point to a policy that says you've known the whole time you've been employed that you are under surveillance, it's just easier to defend and to minimize um, the effect or impact that those arguments could potentially have on a fact finder. Because remember, if you're ever sued, your judge and jury, they're not other cannabis companies. They're not other people who are in the industry. You're going to be up against a jury of people who you don't know how they feel about cannabis, whether or not they approve of it, whether or not they don't. So you're already on that uphill battle more generally. Do things that make life as easy as possible for you, that if you do get in trouble, that you're paying Jill, Hannah, and I the least amount of money possible to make something go away. And you might be laughing and saying, like, well, why are you talking yourself out of a job? We like what we do. We want to help you be successful. We don't want you to pay all your money to us and then go under. That's not our goal here. Um, Next slide, because there's one other thing that you can do that's really going to reduce costs associated with using legal counsel, and that's having a document retention policy in place. We know that under the regulations, you need to keep copies of the surveillance for a specific amount of time. Sometimes we're talking to people who are like, I've got the last 3 years of surveillance because, you know, what does it hurt to have that? It hurts a ton, right? One, I can only imagine how much it costs you to just maintain and store that data. Two, if you're ever sued, you know, the questions that the other side is going to ask us are going to include, give us all the data since the beginning of time about this, that, and the other thing. If you have that data, Jill, Hannah, and I are going to have to search through it to find relevant moments in history or other kind of situations. If, however, you have a document retention policy that says we will keep these documents for this period of time, we keep surveillance for X, Y, and Z period of time, when someone asks you whether or not it's a regulator or it is in the course of litigation for that document or information, and you don't have it, you can very easily say, we didn't destroy it to try to help our defense. Instead, here's our document retention policy. We only keep this information for X, Y, and Z period. As it relates to employment documents specifically, email us after the presentation. We have this wonderful document that sets forth what documents related to the employment relationship you have to keep for what period of time. Every time you post a job and you get 40 applicants, you need to be holding on to those applications for a period of time. And if you're not, you're creating liability for yourself. You don't have to hold on to it forever, but you do have obligations to maintain those files for a period of time. And if any of this is news to you, you definitely want to reach out to us to discuss what should you be holding on to for what period of time. And it's not all 7 years for tax purposes. Everything's going to be maintained for a different period of time. So just keep that in mind. Let's jump to the next slide and talk about making sure that we have appropriate contractual relationships in place in order to protect our intellectual property. Specifically, what happens when our best ideas or our best employees walk out the door? Can they walk out with our intellectual property, with our business model, with all the information that we've trained them with over the last couple of years? And unfortunately, the answer is maybe. If you haven't taken the appropriate steps to protect your business and your intellectual property, you very likely could have an employee who walks out and opens up a competing business using your exact business model. So let's jump to that next slide and talk about it a little bit. There's three specific types of agreements that we see most often that are used to attempt to help employers or companies from having intellectual property walk out the door or lose it to a third party. The first is a confidentiality or proprietary rights agreement, which says like, hey, you sign this document and you agree that we're going to share with you pricing information, distributor and supplier information, sales data, but you can't share that with the public. And if you ever leave us, you can't use that data to start up, another competing business. You may be able to start a competing business, but you're not allowed to use our data or information. When you leave us, we're going to require, if you have any confidential documents or data, that you give all of that back before we leave. So that's a confidentiality agreement. A non-compete agreement is frowned upon in the state and under federal law. What it says is if you were to leave us, you cannot work for a competitor in the industry within a certain geographic range or for a certain period of time. There are better ways to protect your proprietary information than a non-compete agreement, and we suggest a non-solicitation agreement. And what that does is it restricts a former employee's ability to contact your distributors or to contact retail locations, depending on what segment of the industry you're in. And if they were, then you'd be entitled to some type of, financial recourse. So there's fewer restrictions, but it oftentimes provides the same level of protection because they can't use confidential information or whether or not it's supplier or for those your records concerning sales kind of against you. Jill or Hannah, anything to add from that perspective?
No.
Good. Hannah, let's jump into handbooks.
Sure. So the next portion of our presentation is going to look at why employee handbooks are so important and can be a safeguard for your organization. Setting expectations up front helps maintain a healthy work environment and also generally ensures compliance with regulatory and cultural standards. So in the next slide, let's look at behavior policies in particular. So it's critical that your handbook clearly defines the behaviors that you expect from employees and what happens if those expectations aren't met. Using clear, concise language is really key. So you want to essentially spell out what constitutes unacceptable behavior in your work environment. That could be violating company policies, breaking local laws, or behaving in a way that conflicts with your company culture. It's really important to set that out before something happens instead of when you're trying to sort of clean up the mess afterwards. This includes both regulatory expectations as well as cultural expectations. So making sure that the language reflects both the legal and regulatory framework your business has to follow, like state cannabis laws and things like IICs are visible at all times, and other state regulations on things like product handling and so on, as well as internal culture that you're trying to build, like company commitment to inclusivity, teamwork, professionalism, things like that. Having a strong anti-harassment, anti-discrimination policy is a non-negotiables. No workplace can thrive if employees feel unsafe or discriminated. So your handbook should specify zero tolerance for harassment under any protected characteristic. It's also essential that the handbook provides a sort of a clear reporting structure for any complaints. So employees should know exactly who to go to if they witness or experience any inappropriate behavior, whether it's HR department, a manager, someone else. Employees should feel confident that they know who to go to if they have any concerns. The handbook should also outline what would happen when a complaint is made, outlining how a complaint will be handled, investigated, and resolved within the company. Another important aspect is the inclusion of anti-retaliation provisions. Having strong anti-retaliation language in the handbook shows employees that they can report issues without fear of any negative consequences. And then finally, your handbook should outline the disciplinary actions for employees who violate any expectations. So this can range from an informal warning to a termination, depending on the severity of the violation. For the cannabis industry, some sort of special employment issues that might come up are things like employee drug use, impaired behavior during shifts, or maybe challenges related to background checks. The policies should address these challenges head on, maybe not by necessarily spelling out the bad acts themselves, but creating language that goes back to your expectations. If an employee appears disengaged, if they can't follow safety protocol or they can't perform the functions of their job, there would be consequences for that. And Tani will get a little bit deeper into use on the job in a few slides. Tani, do you have anything to add before I move on?
Oh, good.
So I won't go through each of these leave policies, but another critical section of a handbook is leave policies. It's important to sort of ensure that employees understand their rights and responsibilities. The parentheses here indicate the number of employees you need for the type of leave to be applicable to your organization. So for workers' comp, you only do 1 employee, but for the main act to care for families, you need 25. So I won't go through them one by one, but if you don't sort of recognize any of these acronyms or you don't understand one of them, that's a good reason to reach out to us so we can sort of go over your responsibilities and how they should be included in the handbook.
Great. Let's jump to managing the employment relationship generally. We'll actually jump to the next slide too. And the first thing I want to talk about is use on the job. There's no law or regulation that says that you have to permit people to use marijuana on the job, cannabis in any format. It can create liability for the organization as well as safety and health concerns. It may be that that's part of your culture, and that's okay, with the understanding that you can't then call Hannah and I and be like, hey, we want to terminate this person because they can't do the job because they use before they come into work and then they're making really bad decisions. It can't be the fact that they're using if you're allowing everyone to use and come into work impaired. There are safety risks to allowing that type of behavior. If culturally you're okay with taking that risk, that's fine, but understand that we have to treat people, the same based off of our policies and practices. And if we're terminating one person for being under the influence at work, but we're allowing everyone else to do it, that creates appearances of unfairness, which is going to be problematic and evidence of some type of discriminatory motive. So just something to keep in mind. We do have only 2 minutes left, so we'll go to the next slide. But a couple of things that you're just gonna, if you don't have reference in your handbook to any of these laws, OSHA, National Labor Relations Act, Age Discrimination, Whistleblower Act, if you don't have sexual harassment training and posters, these are all required posters and notices. So you need to reach out to Jill or us at some point, soon to talk about making sure you get up to date on that. Let's jump to supervisors. Do not throw around titles. So if you have somebody who you think is wonderful and amazing and they've been with you for 15 years, you do not need to call them a manager or supervisor just because they've been with you for that period of time. As soon as you put the manager or supervisor title on an individual, they bind the organization. If they make dirty jokes at work, it's just like you making dirty jokes at work. If they allow people to violate safety precautions, if they watch people violate violate regulations, it's just as though you are standing in that room watching that same thing happen. You have to have unbelievable trust in your managers and supervisors because everything that they do is binding the organization more generally. So it's really important that you keep that at top of mind. Another really important thing to keep at top of mind is the maintenance of personnel files. So under the regulations, you're required to have personnel files for everyone that has job descriptions and tax forms. It should also, however, have personnel training documents, I-9s. If you ever receive a request for a personnel file from a law firm or from a former employee, please contact Jill, Hannah, and I because personnel file is very specifically defined under the law, and there's a ton of documents that need to be included in it, not just the things that you might be putting in the file cabinet about the employees. And the last thing, we're right on time, so I mean we're a little over, but I just want to talk on the next slide about employee samples. Make sure that your organization, if you're in adult use, this is an adult use aspect of it, but make sure you're following the regulations concerning employee samples, something that we're seeing more and more of that we're talking about. I'm going to turn it back over to Jill for closing remarks generally. So I apologize that in the last couple of minutes, we've really kind of run through things, but we do want to be mindful of your time.
I really want to thank Tawny and Hannah and everybody at Verrill that helped us put this together today. And thank you all for taking an hour out of your day to attend. I will tell you, besides the issues that I deal with all of you for the regulatory compliance, labor and employment compliance, workforce compliance is the number one thing that crosses my desk. And it was a driving factor in moving my practice to Verrill. There's nothing more important other than, of course, regulatory compliance than how you manage the workforce. So I'm glad that we could spend this time today. You'll get this presentation sent to you. We have other resources on our website, and we are always here for you.
Thank you all.
Thanks, everyone.